Okay, let's get started. Hello, everybody, and welcome. Thank you for attending the book talk, The Genome Defense, Inside the Epic Legal Battle to Determine Who Owns Your DNA. The Petrie-Flom Center, the Harvard Law School Library, and the Harvard Bookstore are delighted to bring you this event. Before we get to the discussion, a few housekeeping items. We welcome audience questions for our speakers, so please submit your questions. Throughout the entire event, we'll be pulling those questions to pose to the panelists. You may be asking yourself, how do I submit a question? The best way to do it is to use the Zoom Q&A feature, which if you scroll down to the bottom of your window, you'll see a line and a button marked Q&A. Just type your question in there. We'll be checking it very frequently. You're also welcome to join the conversation or submit questions on Twitter using the hashtag Genome Defense. That's hashtag one word, Genome Defense. Again, that's Genome Defense. If you do submit a question there, the Petrie-Flom staff will be monitoring it and we'll pull it into the Zoom Q&A feature. Ways that you should not try to submit questions is the raise your hand feature on Zoom. We'll not be checking that feature. We've also turned off the chat function so that our panelists can really focus on what's going on. So that's not going to be an avenue for you to submit questions. If you're interested in this event and interested in other health policy, bioethics, biotechnology topics, we strongly encourage you to sign up for the Petrie-Flom Center's newsletter, to read the blog, Bill of Health, and which features some really cutting-edge commentary by legal scholars, including some of the people you'll hear from today. Okay, with that, I get to now launch into the event, and let me introduce our three speakers. We have Jorge Contreras, who's the author and a professor at SQ Quinn College of Law at the University of Utah. Jonathan Kahn, professor of law and biology at Northeastern University School of Law, and Jessica Silby, the professor of law and the Yannakakis faculty research scholar at the BU School of Law. They have illustrious bios. We could spend the entire day just discussing their bios, but we're going to leave it short. It's up on the website if you want to see. And instead, we're going to talk about this book, The Genome Defense. So I'm going to start with just a brief introduction before we hear from the panelists. When you pick up a book on patent law, you don't expect it to be a thriller. But this book, The Genome Defense, and I'll return to that title a little bit later, really is. It tells the story of AMP versus Myriad, the US Supreme Court case on whether human genes could give rise to patentable subject matter under Section 101 of the Patent Act, a question decided in a case about Myriad's test for the BRCA gene related to breast cancer. But the first 264 pages of the book are about what happens before we get to the US Supreme Court. And in my humble opinion, that's all for the better for a number of reasons. But perhaps most notably how Sphinx-like and unsatisfying the ultimate opinion from the court in the case is, right? So if you read the Supreme Court's decision, it's really unsatisfying, whereas this book is incredibly satisfying. Now, full disclosure, I show up as a minor character towards the very end of the book, having had the privilege of representing Eric Lander of the Broad in an amicus, now OSTP, in an amicus brief before the Supreme Court that got some attention during oral argument. As a result of my own involvement in the case and having taught the ongoing controversy in my course on reproductive technology and genetics here at HLS for many years before the decision, I was extremely familiar with this area of law. That fact contextualized what makes this book such a triumph. While it's definitely about law, it's also, and more importantly, a story about people and about litigation. The book begins with my friend Tanya Simoncelli, a protege of my dear colleague Sheila Jasanoff, who at the time taught STS at Cornell, who is about to accept a PhD program offer at MIT, when she spots an unusual ad at the ACLU to help serve as a science advisor for the litigation group. She interviews and gets the job, and the history of patent law changes as a result. What is absolutely delightful about this book is that it renders its cast of characters with a combination of the economy and momentum of a John Grisham thriller and the psychological reality of Tolstoy. There's Chris Hansen, one of the ACLU's quote-unquote free-ranging Jedi masters with the authority and financial backing to pursue whatever causes concern them the most, unquote, and a major force behind the case. To give another example, there's Lisbeth Siriani, a, quote, petite native of Newton, Massachusetts, with sharp features and an acerbic wit, had spent decades working at Blue Cross Blue Shield. She was a graduate of Boston College, the daughter of a civil engineer, educated, vegetarian, divorced, unquote. She develops breast cancer and wants to know if she has the BRCA mutation, But Mass Health does not offer the test because it would not pay more than a certain amount and did not allow balanced billing to the patient, and there was no other game in town than Myriad. The book does also a great job of rendering Myriad's key decision makers in human terms as well, something that I think a more polemic writer would fail to do. As I read the book in some ways, I thought it'd be great reading for someone interested in lawsuits and litigation more generally, even if they had no interest in patent law or the subject matter. George maps all of the fine-grained legal decisions that go into building the case and what to do about it. There's a long, excellent discussion on which gene patent the ACLU should go after and what BRCA had going for it in terms of public recognition, the ability to put the case in a feminist litigation perspective, and also what it had against it. There's an in-depth discussion of which plaintiffs to choose from both a standing and a public relations perspective. There is the battle for the government's position in the case, with the disagreement between Ray Chen, then the solicitor of patents at the PTO, and some Maine justice, including my old friend and coworker, I was in that office, Mark Freeman. There's in-depth analysis of argument prep and things like the choice of metaphor to explain a very complex case. The magic microscope discussion is one of my favorite parts. Then there is a series of opinions and jockeying within the Federal Circuit that set up the ultimate Supreme Court case after remand to consider another case. If the final product is all that matters to you, you miss all of the contingency, all of the decisions, all of the human drama behind it. The last 30 pages of the book, an appendix, give George's view on the underlying law and the policy of the Supreme Court's decision. And this is one of my two critiques of the book, but one he might like. The first critique is that 30 pages just feels too short. I'm sure it was a battle with the press to get it in there at all, but for folks like me, I would have loved a book just on George's views about how this case changed patent law for the better or worse and changed the biotech industry. The second critique I have is the title, The Genome Defense. Don't get me wrong, it's punchy, and I'm sure the press pushed for it, but I just don't get it. It makes it sound like this is a defense offered by somebody in court, like my genes made me do it. Maybe in defense of the genome, but again, the whole idea of defense seems to miss what the case is about and what the book is about. Luckily, you only have to see it on page 1. The other almost 400 pages make you forget it was there and love it. The book is a triumph, and George is to be congratulated. And now we're going to hear from two other readers, and we're going to start with Professor Silvey. So Professor Silvey, you will unmute and unvideo mute. I'm turning it over to you.
Great. Thank you so much. I think, Glenn, you and I had similar experiences of this book. And I just want to thank George, actually, first of all, for writing what is really a thoroughly enjoying book to read, cover to cover, actually. And as we all know, among academics, reading a book cover to cover is actually quite a rarity. So there's so much to talk about this book, and I'm going to amplify some of the things that Glenn said and then move on to some other points of interest that relate to some of the work that I've been doing, and then end with some questions for George. So this book is remarkable for its readability, its character development, its details, its scenes and suspense. The pace is just so impressive. Actually, it really went very fast, and it has all the vices and the righteousness of a Hollywood blockbuster. I've studied trial films and courtroom dramas for a long time in graduate school, and this really feels like it could be a movie. I want to encourage the screenwriters out there to work with George. Halfway through the book, Hans Sauer, who after the summary judgment hearing in Judge Sweet's Southern District of New York courtroom, he comes out, George describes him coming out, seeing the crowds on the courtroom steps after the summary judgment case in a patent case. And he said he realized this wasn't a patent case. There were all these crowds. Patent cases were dull and technical, long and complicated. This was something entirely new. This was theater. That's what George wrote that Sauer said. And of course, it's much more than theater. Sauer calling it theater diminishes the tangible human realities of the case. What he meant, what Sauer meant, I'm assuming, is that it's not entertaining smoke and mirrors. The case is going to be dramatic. It's going to be intense. And it's going to go way beyond the judge and jury in the courtroom. No jury, obviously. But so George, you've really written a legal thriller in the vein of Civil Action or Buffalo Creek Disaster. And I predict this is going to be a classic. So just as some examples to tease the audience a little bit and to amplify what Glenn said, yes, Chris Hansen is the reluctant leader turned crusader. You know, he wasn't in this to refine patent law, George writes. For him, this was a civil rights case. So you can feel the momentum of the righteousness there. And Tanya Simoncelli, the non-lawyer heroine who's credited with originating the case and asking that first important question: how could genetic codes inside a person's body be owned by a company? George provides these descriptions of her working every night at the ACLU until 7 p.m., coming home and then eating a bowl of cereal and then practicing her cello, actually, because she was a very devoted musician, for another 3 hours. The details like this make her so likable, and we're like rooting for her the way we do heroines in other movies. Then there were the villains like Mark Skolnick, who's the head of Myriad, who, when asked about why he got into the race to sequence the BRCA gene, he said, quote unquote, "We did it to win the race, to beat the other team, period." And then he shrugs, George writes, and said, "And we won." There's the sidekick villains for comic relief. For those in the audience who know the Federal Circuit, Judge Randy Rader plays a role in this, described as a lantern jaw with a penetrating gaze. Supporting characters like beloved Dan Ravitcher, the rogue cleric dubbed the Robin Hood of the patent world. And for law professors like me, the name dropping was just so delightful. The personality descriptions of some of our friends and colleagues, of Dan Burke and Josh Sarnoff and Becky Eisenberg and Rochelle Dreyfus of UC Irvine, DePaul and Michigan and NYU, are all mentioned with wonderfully accurate details. I hope everyone is humbled and amused by it all. So for those who follow the blogosphere, Gene Quinn, the vitriolic blogger, makes an appearance in this case. But it's not just the characters, actually. There are scenes in the book that are filmic in their effect. So he describes Main Justice in DC with the 5 marble staircases and coffered ceilings painted bright blue, green, and red, and the murals that people have been there, the murals of American history, which are just astounding. And he describes the busyness of the Southern District of New York, where, quote, anything was possible. There's all this, all this innuendo in the scenes. And then there's sentences like the following I'm going to read. You'll have to bear with me, but they're just such beautiful and evocative ways to begin a story like this, where this isn't just about patents. It's about life or death, as Glenn said. It's about whether the law will align with our ideas of the common good. So George writes, quote, "The genome remains one of the great mysteries of science. Like the deepest trenches of the ocean and the farthest reaches of space, what we have learned about it is dwarfed by what we still don't know. Though it's as close to us as it can be, coiled and working relentlessly within each of our trillions of cells, exactly how it makes us who we are still defies understanding. It is biomedical science's last frontier, a sprawling dark continent, unspoiled and unknown. To Simoncelli and Hansen, the very notion of laying claim to this common domain of humankind offended the conscience. It shouldn't be done, and it had to be stopped." So that, you read sentences like that, and you are in the middle of a page-turner book. Then there were moments, comic moments. So Glenn mentions Lisbeth Sirianni, one of the cancer survivors that was harmed by Myriad's patents. So after she finally got the BART test to confirm the genetic mutation, a representative of Myriad called her, George says, saying that they were so glad that she finally got the test and that they helped her get the test. And then George writes that Lisbeth thought, and that she knew where this was headed now that she had been fully tested. This is his quote. "The woman from Myriad wanted to know if she was no longer going to be a plaintiff in the case." George writes that, quote, "Sirianni laughed and said, 'It took me 3 years to get the test, asshole. I'm still a plaintiff.' And then she hung up the phone." So you read these passages and you can't help but, shake your fist in the air in solidarity. So I could go on and on about the book and the details. I suggest people buy the book the minute it is available and read it for yourself. It is so, so enjoyable. But let me move on to some other questions of the research and framing that the book provides, which I think is worth thinking about more as we consider how IP is changing in the 21st century and how fights about IP are shaping expectations for what we think intellectual property is for and what it means for law students, for IP lawyers, and for social justice activists. So I have 3 small points. The first is that, if it isn't obvious, that this book demonstrates that IP battles are political battles. They're civil rights battles, and they're fighting over who has been left out and left vulnerable. IP is about the lived experience of real people. And this book reminds us that it was not so long ago that intellectual property cases were just not in the news that often. IP lawyers were those sort of technocratic lawyers isolated in law firms that did specialized things that most people didn't understand so well. And the folks in the room that maybe know a lot about admiralty law or ERISA law, I mean, it was sort of like that, still sort of like technical little enclaves, important, but still highly specialized. But today, IP law and IP lawyers are central to law practice generally and to legal education. IP is centered in legal culture today, and even in popular media culture. It's imbuing IP with generalized and fundamental values as it becomes domesticated by everyday legal and popular life. And so as the Supreme Court, as we know, takes more and more IP cases as it is, those general narratives of American law, be it the rule of law or representative democracy, the importance of certain fundamental rights, they become as important to the story we tell about IP as well. And this is a shift in IP law. And the Genome Defense is a detailed accounting of that shift in a single important case. So the book demonstrates that this case is about the stakes beyond the utilitarian idea of IP, beyond money and investment-backed guarantees, beyond a consequentialist theory of intellectual property, which dominated IP doctrine and theory for the second half of the 20th century. The economic and narrow-minded market framing is demonized, perhaps rightly, in this book as single-minded and selfish, and in the private, not the public interest. So in the Myriad case, as the ACLU shapes it, it's actually about the ethical provision of medicine. It's about our shared fate in access to information and healthcare. It's about women's rights, autonomy, and choice. Sandra Park, one of the ACL lawyers and heroines in this case, wrote that the ACLU, she brought the case with Chris Hansen, that the theory of the case and the way it was litigated was framed actually by feminist values. The personal is political, raising up women's voices and collective narratives. And the book illuminates these feminist values and how it describes the case as litigated and the issues it highlights, how caring about the right outcomes in IP cases has feminist implications, consequence beyond markets and investments. It bears on the ability of humans not only to flourish, but to survive, and it's about self-determination. Madhavi Sundar, another law professor in IP, has written about the Myriad case, and she says, quote, IP's march into all corners of our lives and to the most destitute corners of the earth exposes the fragility of its economic foundations while amplifying its social and cultural effects. George's account of the Myriad case admirably channels these feminist ideals and philosophies of human flourishing. The second short point I'd make is that the book lays bare several of the myths of IP, some of those that the exclusive rights are necessary to incentivize art and science, the simultaneous and parallel research into mapping the human genome that this story tells shows how this discovery would have happened without the patents. And with all the simultaneous invention and grief over Myriad getting there first, the book asks us to consider if others had gotten there before Myriad and it was close, would there have been such injuries and heartache? It also busts the myth of the sole or lone inventor. The domain of the human genome and all the knowledge it produces is quintessentially collaborative. All the triumphs in this book are described as group endeavors. The important story of Mary Claire King, of Eric Lander, the 9 points ethical licensing code, challenge IP's theory of individualistic and capitalistic model of productivity and efficiency. Finally, my last point, and most briefly, the book demonstrates how critical it is for IP lawyers and IP law to evolve alongside the 21st century's technological and human developments and the crises they entail. Our shared fate regarding the harmful effects of climate change and reversing the Earth's warming, the public interest in accelerating access and advances in healthcare, the recognition of broad and diverse stakeholders in creative and innovative production go far beyond our traditional view of authors and inventors and rights as owners. The circumstances of our 21st century urge a shift from that dominant focus on market-driven production to at the expense of progress of science and the useful arts, to a focus on and the elevation of the public interest to which the IP is supposed to aim. the Genome Defense meets these challenges with resounding success. So I'm just going to end with 2 questions for George and then pass the baton. The first is whether in writing the book with all its details, it must have been hard to leave certain things out, or maybe you anchored the story around certain fundamental moments. I would love to hear, maybe the audience would too, about maybe some juicy details that were not left in, or maybe how you crafted the narrative that was so compelling. And the second question is about whether you think the genome is special in terms of the larger story of civil rights and IP that you tell, or are there other aspects of patentable subject matter or patent doctrine that you think this kind of ACLU advocacy could move to next?
Big round of applause virtually for Professor Silvey. And now we'll hear from Professor Khan. Go ahead, Professor Khan. Feel free to unmute yourself.
Hi, thanks. That was great. And I sort of want to, I guess, join the fan bandwagon here. It was just a delight to read this book in all sorts of ways. I should sort of echo all of the comments about the readability, the engagement, the pacing. I love the idea of turning it into a movie. I'm already starting to think, like, who should we cast for different, different roles in it. But I'm going to start out talking about really just how, in addition to just the pleasure of the book in its own right, is that it's also really a very timely and both, I would say, a timely intervention and also a useful historical chronicle of a very important moment in the progress both of intellectual property and of genomics and biotechnology. Its timeliness is really related to questions about how the law can both promote and inhibit and mediate access to critical health interventions. The BRCA testing told in the Myriad case is really a foundational example of how the widespread entry of genetic testing and genetics generally into people's everyday lives is, shapes in very profound and direct and personal ways how people are able to live their lives. And of course, in many respects, I find these issues timely because they are very central to current debates about what's going on with access to COVID vaccines and therapies. And I know George is very directly engaged in this issue as well. And so perhaps at the end, I'll ask him to sort of reflect on certain connections he may see between this book and his current work on trying to promote access to COVID-19 vaccines and issues of how patents should be managed and mediated in that realm. And perhaps that'll be the basis for his next book. But it's also a chronicle of a case that was many years in the making and is now itself almost 10 years old. But it provides a really detailed and nuanced reading of the many, that's refrain from saying myriad factors that inform and shape and drive the story of the development and management of technology, of the various technologies and practices behind the development of BRCA testing. So in this regard, it's a highly technical story in many respects of both law and science. But again, to sort of echo what both Jessica and Glenn were saying, it's told in this very humanized, powerfully narrative way that provides a real entry point into what could be, again, these sort of deeply technical discussions, but it provides an appreciation of sort of the interaction of the human drama, the contingency, the dynamics of scientific discovery and the development of legal strategies and argumentations. Again, the references earlier to like mooting cases and the development of sort of like legal metaphors and things of this sort that provide a sort of wonderful entry into this, what could otherwise be this very, very complicated story. Makes it again, very accessible, not just a pleasure, but provides this avenue of access to this very complicated area that is just fantastic. And so, it's in this respect, well crafted and narratively strong. It's refers to the epic battle. The story itself is an epic, and told like an epic. And it's always linked in this, I find, in George's writing and approach to this, always links the story to a deeper exploration of the significance of what really is at stake in using law and politics to control access to these kinds of critical technologies that have direct impact on individual people's lives. It is a particularly nice exploration of the role of these diverse actors in challenging the patents. Already, again, earlier, Jessica and Glenn both discussing some of the key actors, particularly at the ACLU. In regard to this, I found particularly interesting the exploration of telling the story of how the ACLU, the American Civil Liberties Union, shifted its focus here and came to see that that intellectual property can be an issue of human rights, which is a radical change and reconfiguration of sort of the traditional role of the ACLU. And I love the discussions of sort of how the ACLU lawyers, in many respects, and often sort of prompted and prodded by Tanya Simoncelli, sort of started to rethink about the role of a civil liberties organization in a world of so dominated by biotechnology. And it just really, this discussion in itself, I just found broadly significant in terms of reconfiguring our understandings of sort of like where civil liberties lives in today's legal and technological world. The case itself, I think Glenn gave a very nice sort of general overview of it. Coming down to this idea and framing it in terms of who owns your genes, some of the background doctrine, the idea being that you cannot patent a product of nature, so how can you patent your genes? Again, I think Glenn referencing Tanya Simoncelli's sort of like bafflement at encountering this. But the thing is, and one thing I'd like to talk a little bit about here is, of course, the dividing line between nature and the patentability of relevant quotation here of anything under the sun made by man, which is from a case called Diamond versus Chakrabarty, which George discusses in the book. This dividing line is legal, it's not scientific. And that's a critical thing here. And so hence, ultimately, in the resolution of the Myriad case, you have this distinction made in what Glenn rightly characterizes as a kind of unsatisfying opinion between DNA, just sort of naturally occurring DNA in your chromosomes, and what's called complementary DNA, which is DNA that has been produced through a complex intervention that sort of separates out coding and non-coding parts of the genome, so that you're getting strands of just sort of the parts of the nucleotides, the CAGTs that code for actual proteins. And the cDNA is patentable, but the DNA is not. Sort of, a quick and dirty summary of the resolution of the case. But so what is at stake here? I mean, and there's just so much at stake. It's obviously not just about Myriad and about BRCA testing. It's about, and Glenn and George does a great job of this, about situating the progress of scientific discovery in a social and legal context, where you appreciate how each shapes the other. In particular, again, Jessica referencing the way in which feminist considerations and framing sort of enter into this construction of what's at stake and how the science is progressing, and the law. There's this sort of intricate dance going on of science and law here, and as I say, each shaping how the progress of each is occurring. And it's about the legal management of genomic information in a world where increasingly, to know your rights, you must know your genes. And that is, I think, what really was a kind of hook that got the realization that got the ACLU into this. And ultimately, it was the culmination of a debate about patenting genes that had been going on for well over two decades. And in this debate, it's about, in many respects, at what, not sort of just like, are genes patentable, but at what point might they become patentable? And in this regard, it's in the world of patenting, there's this notion of the stream of invention. And there are different sort of way stations or stops along this stream where you have a gene that exists in nature, but then it is sort of brought out of nature into the lab, and then it's turned into a product, and then it is provided to a consumer. And the trick really becomes the designation legally, not scientifically, of at what point genomic material becomes patentable, right? At what point does it leave nature? And one of the things that I think, again, that George does great in this book is an analysis. This is sort of a more of a technical legal area, but an analysis of the concept of purification and isolation, which plays a big role in this doctrine, and showing that that's not what's really going on in the genomic situation. But to realize that what's going on here again is not a scientific purification of anything. What you're doing in order to patent a gene is you're essentially legally purifying it of its associations with nature. And that's when sort of the law draws that distinction of what's critical. And different actors have different stakes at sort of when this line is drawn. So the idea is, like, if you're a basic scientist, in many respects, you don't want the world of patents. And we see this in sort of discussions of people like Harry Osterer, the New York researcher, or Mary Claire King, both genetic researchers, where they want to keep the lab as a space for pure science, where it's sort of this liminal space between nature and man-made, where scientists are still free to manipulate these products without being inhibited by patents. But then you have a sort of world of commercial science where you want to be able to see the lab as a space of transforming, where you are taking something from nature and transforming it into something man-made that then becomes patentable. And certainly if you're a small biotech company, especially in the early years of the patent rush and genomic discovery in the early 2000s, you're going to want something to be patented as soon as possible, because it may be that you don't produce any pharmaceutical products, but your gene patent becomes your product, your patent portfolio. But ironically, some large pharmaceutical companies, your Mercks and your Pfizers, might not want something to be deemed patentable until much further down the stream of invention, closer to the kinds of products, the pharmaceutical products or interventions that they have. Because that works better for their business model. And then you have health activists who are concerned about access to essential medicines, believe that should override all patent rationales, essentially. And so where do we end up here after this story and the sort of splitting the baby of the opinion where DNA is patentable, but cDNA isn't? Well, the first is sort of the irony of Myriad's loss in this case was that the company itself did fine. And it continues to do fine in terms of like its stock valuation and so forth. And what we see is, behind this, the power beyond the power of the patents themselves for Myriad was the power of its proprietary database that it developed through having a patent monopoly over the genetic testing for so long. But also, I think, coming back to what I mentioned at the beginning of my comments, was thinking about the implications of this story for things such as George's work on COVID-19 vaccine access, and vice versa, how they might inform each other. And again, I'd love to hear George speak to that. And then also a couple of additional final questions for George is, how does this story then reflect on the underlying rationale of patents as a spur to innovation? And should this lead us to rethinking about subject matter specific patent rules? The way the patent system works is, the same patent rules apply to all different technologies. And should we be rethinking that maybe and have different kinds of rules for, say, essential medicine technologies or health intervention technologies? And then finally, I'm wondering if this might, one of the big current patent battles in the area of genomics is over patenting CRISPR. And I'm just wondering if George might have any thoughts about that as well. And I'll just wind up there. Thank you.
Thank you so much, Professor Kahn. So now we're going to hear from George for about 5 to 7 minutes, and then we'll hear from the audience with questions. I'm going to encourage people to use the Q&A button or post questions on Twitter because we're going to switch to your questions shortly. Professor Contreras, go ahead.
Great. Well, Glenn, thank you so much. Thanks for hosting this event with these wonderful comments from three really close readers of the book. And I just have to say, having you three read and comment on the book is a real treat because I have admired your work over the years, all three of you. And so I'm very glad to be part of this conversation. So I'll just respond a little bit and answer some of the questions that you've asked. And I could go on all day with this, but I'll try to be quick. So, this story in this case, I think patent lawyers, patent scholars, and even some scientists realized as it was moving along that this was an important case. It was going to remain important, and it was going to have an important impact on the law and possibly on science and the biotechnology industry. But very few people outside of that small-ish community realize that. As several of you mentioned, combining patent law with human genetics, that doesn't make for a very easy to understand combination in most cases. And most people who I talk to who are outside of this field, even other law professors, who are very well educated, didn't really know anything about it. And to me, the story and the lessons to be learned from the story were so important that I really thought this ought to be presented to a broad general audience in a way that they can understand outside of the academic legal literature. And, I've contributed my share to the law review literature and so forth. But I have no illusion that not very many people read that stuff. And so back before I became a law professor, I was a lawyer, and I worked at the law firm that happened to be featured in the book and then the movie A Civil Action. Actually, some of my professors at Harvard were also involved in that case as expert witnesses. And a civil action is really what planted in my mind years and years ago, before this case even came about, that you could tell a complex legal story that involved science in a way that would be interesting to people. And then, have a movie that John Travolta and Robert Duvall star in around that story. Lots of people heard that story, and I think a lot of those people know more about environmental contamination litigation than they did before as a result, and I think that's a good thing. And one thing, though, about writing a nonfiction book like this, and listening to some of the quotations and the lines that you've read is, to some degree, I feel like an imposter, because many of those words and impressions, those were directly from the people I interviewed. I interviewed almost 100 people for this book. It took 8 years to write, and I have literally thousands of pages of interview notes and transcripts, and FOIA requests, and a lot, and so I am highly confident that it's accurate. I didn't make up a lot of stuff, and I even got the main characters to look over manuscripts and give me corrections, and they did. They made lots of corrections, and I'm very grateful for all of the people who played either very small roles or very large roles, who were patient enough to explain it to me, to tell me what happened, to entertain numerous repeated questions and follow-up from me, because my goal in this was to tell this story in an accurate way, and not to be polemical, and to be as balanced as I could. And clearly I submitted an amicus brief along with Josh Sarnoff and other law professors on the ACLU side. I made that very clear up front. Nevertheless, I wanted to tell all the sides of the story, and I didn't want to caricature anyone. I did not want to paint Myriad, the company, or certainly the people there as villains in this story. And Mark Skolnick was very generous with me with his time, and he shared a lot of thoughts with me. And what I hope I presented is an accurate vision of him. He's not a villain. He's a scientist, and his views and his reactions and his attitude toward the race to sequence the BRCA genes, that's the view, that's the attitude that many scientists have, right? And so this is a reason that, as smart as they are, scientists should not run the world. They have a different set of concerns than politicians and policymakers and lawyers and advocates and others. But all of those people were part of the mix in this really complex and multifaceted story. So there is a lot that I had to leave out. This is the first book of a trade nature that I've written for a general audience. I've written like 10 or 11 other books and edited other books that are academic books that, again, not that many people have read, but are published in a very different way. And so both Glenn and Jessica, I think, had questions about how some of these decisions got made. The title, oh boy, the title was not my title, but this is probably the 5th title that the manuscript had, and there were probably 50 different title candidates that the marketing department at the publisher put forward because they absolutely hated the title that I liked, which was A Product of Nature, which I thought plays kind of nicely in a clever way on this patent law doctrine about a product of nature. But they said, that sounds like some kind of natural food or something, like a Whole Foods ad, not a legal thriller. And so, there were many decisions like that an academic publisher never would have raised, but that my publisher, which is Algonquin, which is now part of Hachette Group, was very hands-on and very interested in how this book would be perceived in the world, and helped quite a lot. I can't say enough good things about them. But that being said, there is an entire history that I researched, interviewed people for, and wrote of the early history of discovering the BRCA genes that is not in this book because it was too long, too many other characters, too many other considerations. But there's a decade worth of history, much of it unknown to even experts, about how these patents were acquired, how the race went down. And, I've definitely got enough on the cutting room floor to create a prequel at some time. That story has been partially told in a couple of other books that came out in the mid-90s, but there is definitely more to it. So as far as the substance, and then I'll wrap up. I am not anti-patent. This is not intended to be an anti-patent screed. My view in all of this, and I thank Glenn for having mentioned that he read the appendix. The appendix, not everybody wanted there to be a sort of legal commentary appendix in this book. I thought it was important that there be one. I wish it were longer also, but I hopefully I got across some of my message there. But my legal point is that, absolutist positions that are often taken in this industry, that, everything that could possibly be patented should be patented, and if not, the innovation infrastructure is going to fall apart. That just doesn't hold true. It doesn't hold water at all. And I know Jessica has written about this in her wonderful book, The Eureka Myth. And I know that all of you have thought about this. The maximalist view doesn't necessarily hold water, but neither does a minimalist view. We shouldn't abolish all patents. That would undoubtedly be a bad thing, right? We do need some financial incentives for expensive R&D to take place. And so there is a balance and a line and a path to take down the middle of these positions. I think the middle path that the Supreme Court took with the guidance of the Solicitor General doesn't make a lot of sense theoretically, but it was, it was something. And I think the most interesting thing, and another point that I really wanted to convey to readers, is just how strange it is, the way that the law is made in the United States and in the common law system in general. I think most ordinary citizens, and I've talked to a lot of them about this, think about the law and think about, municipal traffic statutes and criminal codes and whatnot, and the law is specified in a codified manner. Most ordinary people don't get a lot of exposure to the common law, the vast machinery of the common law as it's created through the judicial system. And that is very important, right? That is a hallmark of the common law system. It is how the law is made, and the inputs to it, including the inputs from the government, from the administration, the Obama administration, which were huge in this case, are very poorly understood, I think, by the general readership. And I really wanted to convey that. And then finally, just to hit COVID very briefly, to Jonathan's point, so as he's mentioned, I've thought a lot about COVID and medications and vaccines and technology around COVID. One lesson to take away from this book, I think, is that when DNA sequences could be patented in the days of the SARS outbreak and the H5N1 outbreak, those sequences were patented very quickly after they were discovered, and that created problems for researchers. And numerous, Matt Rimmer and numerous other scholars have written about those problems. That did not happen with COVID-19 when the SARS-CoV-2 RNA, the viral RNA sequence was determined in January of 2020. It was immediately uploaded to GenBank. Nobody tried to patent it, nor what are probably only 300,000 different variants of that sequence remain open to researchers to use, and that has been an amazing resource. We, despite all of the problems and all of the access and the pricing and the manufacturing bottlenecks, which I am fully cognizant of, research happened very fast, and we did get vaccines at an unprecedented speed. And I think part of that is because we didn't have bottlenecks with patents covering the basic sequence of the virus. That was a free, shareable resource, and everyone has made a lot of money, maybe even too much money, but certainly have made plenty of money, and there were plenty of financial incentives to create those vaccines, even without those patents. So I do think that this case has made a difference, and I sincerely hope that it is not eroded with legislation in the future. Anyway, that's what I have to say, and I look forward to questions.
Great. So I'm looking for questions in the Q&A box. Remember, if you are a questioner, add a question in the Q&A box. I'm going to look to my team to know whether there's any that we've had over Twitter. But while we're waiting, I guess I'll ask this question. Why is Justice Thomas's opinion so bad? Which is just to say, compared to, let's say, the Federal Circuit, and not the holding, right, but the opinion itself, why is it so Sphinx-like and inscrutable? And whether you have any thoughts about this, George, after spending a lot of time on that. We also have another question, just I'll throw this out to you, and you can choose which one to answer, because I'll make sure the audience gets heard. Would love to hear your thoughts on the patent fight relating to CRISPR. So somebody would want you, what your thoughts on that are. Go ahead.
Sure. So many scholars, Dan Burke, I think, has probably the clearest indictment of Justice Thomas's opinion, and it just doesn't make that much sense scientifically, for better or for worse. And again, I agree with the basic outcome that the naturally occurring DNA sequences should not be patentable because they are products of nature. And he does refute the Federal Circuit reasoning that, well, you break covalent bonds and chemically alter the DNA sequence when you remove it from the chromosome. Judge Sweet, I think, said it best in the district court that that's a lawyer's trick and nothing more. But if you ignore chemical structure, for purposes of saying that the isolated gDNA, the genomic DNA sequence, is not patentable. Then he goes back and makes a big deal about chemical structure when he says that cDNA should be patented, right, or should be patentable, because that cDNA is just the coding basis, the coding region of the gene plucked out from the introns, doesn't occur in nature, but the sequence is the same sequence that you had in nature. And that's really the important piece of it. So I think the best opinion in this whole case was a district court opinion by Judge Sweet that changed the view of DNA. As he characterized it as an information carrying device rather than a chemical molecule. Just like when we talk about a computer software program, we don't characterize it in terms of the silicon memory chip that it's on. We characterize it in terms of its information content. CRISPR, there has been Jake Shurko and Hank Greeley and many other far smarter bioethicists and scholars have written volumes about the CRISPR patent debates, which are still ongoing. Who knows how those are going to turn out? I mean, one thing that I would relate the Myriad case back to it, though, and just repeat an observation that actually Bob Cook-Deegan first made to me, and we discussed, is that with gene edits, a newly edited DNA sequence, or a newly created DNA sequence that scientists just come up with using computer simulations in the lab, that to me, that seems like an invention made by man, to use the Chakrabarty language, that should be patentable. Those I think are going to be extremely rare, right? We are not nearly smart enough to create our own homegrown edits yet. What we will be doing is repeating edits that we see from variants that occur in nature, right? So if there are clearly heritable elements for longevity, we will figure out what those are and then use CRISPR to modify germline DNA to insert those into people someday, perhaps. Should those edits be patentable? I would say no, and I think the Myriad case establishes no. If they exist in nature, even in some other person, we found them as a variant there, they shouldn't be patentable. If we eradicated the Myriad decision and the related decisions, conceivably you could say that a variant that I found in person A that I then use CRISPR to insert into person B, maybe I should be able to get a patent on that, and I don't think that you should.
Okay, while we wait for another audience question, I'm going to ask a different question, which is to say, when you look at Myriad's post-Myriad decision, kind of business practices and ability to price its test, is that telling us that all the focus in patent law is fine as far as it goes, but really we need to worry about things like platform antitrust and database creation and stuff like that, and competition policy, so that the next book in the sequence, if what you care about is liberating the genome or liberating the ability of women to afford BRCA tests, the patent piece matters, but not nearly as much as someone might have thought.
Right, you're totally right, so the data, and Jonathan mentioned this as well, right? Myriad's database, variant database, which is proprietary, is an incredibly valuable asset, right? That no one else has access to, and that is definitely a consideration. Another thing that I would throw onto your list is healthcare reimbursement and the whole healthcare payment system, which has Myriad's test is reimbursable now. It was a struggle for them to get it reimbursed, but now it is reimbursed by most systems. The price has gone down, which was one of the main benefits of the case, at least at the BRCA level. But it's still being reimbursed. And if you talk to genetic counselors, they will still, many of them, most of them, I would venture, still recommend Myriad's test because it is, quote unquote, the gold standard. And it is reimbursed by almost all policies. And so even though there are cheaper tests, the reimbursement system says, you can go to Color Genomics and get a $200 genotyping test, which might or might not be reimbursed by your carrier, or you can get this $2,000 test from Myriad, which everybody says is a great test, and it is a very accurate test. And you pay nothing for it, or you pay, you know, your $5 copay. Which are you going to choose? Well, you're going to get the $2,000 test. And so, you know, the healthcare reimbursement system that I've tried to explain very inadequately in the book, and again, obviously there have been many books written about that, is yet another aspect of this whole imbroglio that is important.
So we've got 4 minutes left, and we'll try to get one more question. We got one more from the audience, which is comments on the litigation of Henrietta Lacks's families and the exploitation of HeLa cells. And I often teach Myriad and this material at the same point, but then I explain to the students why the questions are different. So I'm curious what your views are about this.
Yeah, absolutely. Well, I mean, first I will say that Rebecca Skloot's book, The Immortal Life of Henrietta Lacks, was clearly one of the inspirations that led me to write this book. I mean, in my book proposal, when I was, you know, shopping this to publishers, it was A Civil Action and Henrietta Lacks, right? Those were the two books that I pointed to as precedents for this. And I also teach the Henrietta Lacks case, although it wasn't a case until very recently. I teach the Henrietta Lacks case study, as it were, around the same time. And they are different issues. And the case obviously was just filed. It's in extremely early stages, and I haven't actually read the complaint, so I can't really speak to the legal merits of the case. I mean, there are probably many legal hurdles to overcome, including statute of limitations for this sort of thing, and so I won't comment on that. But the difference, I think, that is important is Henrietta Lacks is not really a case about DNA or genetic sequences. It's a case about physical cells. The physical cells in our bodies, we have a quite strong ownership claim to. And I think the question Henrietta Lacks is, those cells were taken from her as part of her cancer treatment at Johns Hopkins, is what was done with those cells later, which seemingly was standard practice at the time. Was that okay or not okay? A rich topic for discussion and debate and further writing, and I hope Rebecca Skloot is out there working on the sequel to her book to cover this aspect of it, which again, I think is going to be fascinating.
Fantastic. Well, with that, let me have Professor Cohn and Professor Sylvie unmute their videos so that we can give them a round of applause. We can see them at the same time. So a big round of applause to our panel, and a big round of applause to George for writing such an amazing book. It's available now or shortly. Pick up your copy. It's a wonderful read. I read it at the beach. I told them this. It can be a beach read. You have to be a little nerdy for it to be a beach read, but only a little nerdy. So thank you very much, and thank you to our wonderful audience, and we'll see you all at our next event. Make sure to sign up for the Petrie-Flom Center's newsletter if you like this event and would like to attend more about this. Thank you again very much, everybody.